Did the state prove its case against George Zimmerman that he killed Trayvon Martin on purpose? Or did the defense prove it was self-defense and raise reasonable doubt among the jury? It's Your Call breaks down the highly controversial case with its longtime panel of legal experts, and the anticipated fireworks start right now. Hello everyone, it's good to have you with us. I'm Lynn Doyle, giving you a chance to weigh in with how well you think each side did in presenting its case to the jurors. Looking at the prosecutors and the evidence that they presented, such as the 911 call from the defendant, the screams on the tape, Trayvon's mother, did they convince you that George Zimmerman committed second-degree murder? Or did the defense attorneys, by presenting witnesses who swore those screams were George's, not Trayvon's, they presented interviews with police detectives and pathologists and others, did they leave a reasonable doubt in your mind, maybe even convince you that it was definitely self-defense? We give you a chance this hour to tell us what you think. So if you want to weigh in, you can start emailing me right now at lynn@lynndoyle.net. I've brought together one of our most opinionated legal panels to weigh in on that and more. And while they really need no introduction to our longtime It's Your Call viewers, I'm going to give you their credentials nonetheless. Attorney Sadie LaDove is a partner in the law firm of Dolchin, Slotkin and Todd. She's a former prosecutor in the Bronx and a past chancellor of the Philadelphia Bar Association. Jeff Gold is a criminal defense attorney with the law offices of Gold and Associates and is a former New Jersey prosecutor who also does legal analysis for the media. Tariq El-Shabazz is a former Philadelphia assistant district attorney who's now in private practice at El-Shabazz and Harris, LLC. And last, and certainly not least, Charles Peruto Jr., who, as you know, is a well-known Philadelphia defense attorney. I have to say, it is great to have you all back together again. Wonderful to see you all. So let's play Monday morning quarterback here, guys, and take a look at each side and break down the case as how well the defense did and how well the prosecutors did. Let's start on this side with Sadie. What would you grade the prosecutor's case if you were giving that grade?
I give them a B+.
Okay, why?
Not a perfect case, but what they did do is they convinced me, Lynn, that it is not okay to follow a young man who is merely walking from place to place with a bag of candy in his pocket. Further, let us assume for talk's sake that there was some kind of an altercation. It required then Zimmerman to engage in equal and opposite force, not to take out a gun and shoot this kid to death. So they convinced me.
Did they convince the jury, though, will be the question on everyone's mind. So, Jeff, break down the defense for me and give it a grade.
Well, first of all, the defense was the state's case. Every witness the state put on in this case was a defense witness. The best moment that the state had was its opening statement with a very handsome John Guy. That's it. After that, two of the witnesses that were the best for the defense were Rachel Janelle, who said Trayvon called him a creepy-ass cracker, and then also John Good, who was a state's witness, who saw, an eyewitness who saw Trayvon pummeling George Zimmerman.
Tariq?
That's the most hilarious thing I've ever heard in my life. One of the things you do as a prosecutor is you don't hide evidence. So you put on what you have. You don't select your witnesses. You bring the witnesses that actually observe things. That's the first thing. The second thing is whether he was called a creepy-ass white man, a creepy-ass cracker, or anything else had nothing to do with what Zimmerman did. Trayvon never said it to Zimmerman. He was talking to someone about some man that he didn't know, following him for no reason at all. That's how people get snatched, put into vans, and all of a sudden they show up in particular houses. 10 years later, no one knows that they ever lived there. The third thing is, and I think I said 1, 2, so let's go to the third thing. The third thing is Janelle, Miss Janelle was who she was, Miss Janelle. And she tried to express herself the best she could.
When you look at this case, Chucky, do you think reasonable doubt was left in the minds of the jurors?
I don't think it ever left. Mr. West, the defense attorney, reminded them that he doesn't have to prove that his client is innocent. They have to prove that he's guilty. And they have fallen far short of that. I'm wondering what the plea offer was in this case, because he had to know how strong his case was going in. And it certainly didn't come out any better. And I was wondering, what was the plea offer? It certainly had to be some sort of an involuntary manslaughter or accidental
killing.
Except
when you put forth an affirmative defense, which self-defense is, it's an affirmative defense. You do have a burden of showing some things. That's the first thing. And they tried to do that. They tried to do that through the tapes of Zimmerman and many contradictory stories that he gave. But if this was in Philadelphia and Pennsylvania, in the Commonwealth of Pennsylvania, it's a no-brainer. Even if it's manslaughter, it's clear. Why? It's a
no-brainer which way? A no-brainer which way?
No-brainer guilty.
It's not
No-brainer guilty. Then I must have lost my mind because
you've been lost your mind. Losing your mind now is nothing different than a couple of years ago. But at the end of the day, it's something called unreasonable belief of self-defense. That's when you think that you have to employ the right to kill somebody.
It's got you on the ground.
And he's beating you up. He's beating you up.
Are you telling me?
He's beating you up after you follow him.
So what?
He don't know who the hell you are. And he didn't pull out a gun, a knife, or anything else. Put your hands up and fight back.
What are they going to do? Pull out a bag of Skittles and shoot him with a bag of Skittles with a manual over it? What are you, crazy?
Trayvon attacked George Zimmerman, period.
And the detectives were the best witness for the defense. The detectives agreed with Mr. Zimmerman that he had to do it.
Okay, let's start
It doesn't
with.
matter if the detectives agree. It matters if the jury agrees.
Let's start with
No
some
doubt.
of the basic evidence that was presented, and one that captivates me. I'm sure it captivated our audience as well. And that was that 911, the various 911 calls, and all of the testimony that surrounded the so-called screams that were heard on the tape. Why, in this day and age of technology, the way that it has advanced, are we not able to determine who was making that noise?
All right, let me help you here. This is called the Fry test. This is something that came out from the Supreme Court several years ago. It basically says to the judge, you are the gatekeeper of the evidence that comes in. The technology has to be sound and reliable and accepted in the general scientific community. If that technology isn't sound, reliable, and generally acceptable,
it's hooey science.
You cannot get the evidence
it's hooey
in.
science. But you know what really is hooey? Is that eyewitness testimony is inherently unreliable. Ear-hearing testimony is also unreliable, which is why you have 8 people saying it's one person, 3 people saying it's another. In the end,
So
it's
does
the
it,
state
does it wipe itself out?
Well, no, because
There's at least a minimum of a reasonable doubt as to who the caller was.
Okay, so that
at
would,
least a minimum of
could
that.
that be determined
As to
or
who the caller-
established as a win then for the defense, because no one could definitively
The
say
state can't
who
prove
it
a
was?
case.
Any
can't
point that
prove
You know what they
the
can
state
prove?
cannot prove beyond a
Let's-
reasonable doubt
let's
is a
begin.
win for the defense.
Let's
They don't
begin.
have to prove that it's Zimmerman. They just have to make sure that there's a doubt that it's Martin.
You know what? Why? Why? It's more
Constitution.
important. Hold on.
The Constitution.
Not why they have to prove it. Why is it that important that it's Trayvon Martin? It's only important to rebut a self-defense claim. If we take this case as what it is, we have a 911 call that is indisputable. These effing punks, or whatever he called them, always get away. That tone of thought that gives us his frame of mind. Sir, don't get out of the car, don't follow him. He follows him anyway. That frame of mind. He made 8 or 9 or 10 or 25 calls earlier, prior to this, about people walking in a particular neighborhood. He confronts him.
Well, wait a
We
minute.
know he confronts him.
But
We know he was confronting him and he was close, because we know that
No,
from the
we don't know
independent
that.
scientific
No, we
evidence
don't.
that shows
We don't
stippling
know that.
around the wound, which means that it was within 2 to 4 feet of
Stick to
actually
the
being
tape.
shot.
Stick to the tape.
What I'm saying to
tape-
you, no, what
The
we're
tape
talking
shows
about.
George Zimmerman was screaming for his life.
No, the tape doesn't show that. The tape shows that you want to believe that George
somebody
Zimmerman
was screaming.
for his
Okay,
life.
what
The
we-
tape shows that
What
somebody
we're going to
was
ask the
screaming for
audience
their
is,
life.
who do you think it was on that tape, and did either side really prove to you definitively that it was the person they said it was? Which side do you think did a better job in presenting its case? And do you think there was reasonable doubt? And we also want to ask you what you think might happen after the verdict. I mean, how do you think it's going to go over? If you want to join in, you can email me directly at lynn@lynndoyle.net. You can also find us on Facebook and Twitter. It is burning up there. Stay with us. We're coming back with our favorite legal panel in 2 minutes. Welcome back to It's Your Call, where we are talking about the George Zimmerman murder trial. Of course, as you know, it has captivated the country for the last couple of months, and we're giving you an opportunity to weigh in now as we do a little bit of Monday morning quarterbacking, or Monday morning jurying, I guess we'd say. We're asking you, if you were in that jury box, how you would have voted one way or the other. If you want to join in, you can email me, or you can also find us on Facebook and tell us what you think there. I do want to return to some of the evidence that we've been looking at before we check in with your responses on Facebook and get the observations from both the prosecution perspective and from the defense perspective. We talked about those 911 calls that came in, and of course a lot that was spoken about during the trial and the coverage of it was identifying the voice who was screaming for help. Obviously, we can't say definitively here among the five of us who it was, because they couldn't say in court. One person said it was George, one person said it was Trayvon. The thing I wanted to talk about was the mothers. I was really unmoved by their testimony, and I would have thought that that would have been a place where one side or the other really could have dug in with the jurors and gotten to the heartstrings. What happened there, Sadie?
You know what, Lynn? We've said on this show many times that people grieve in different ways. These mothers are grieving. There will be no winners and losers in this case. A dead child will not come back. A son will be lost to the system. There's no winners here, so I think these mothers are also numb.
Yeah, that's also poor preparation by the trial lawyer. You have to prepare your witnesses. You have to prepare your witnesses.
Chucky, you can't make somebody cry if they're numb. These people are absolutely shell-shocked.
Her behavior is
shell-shocked.
All right, well, let's say the moms canceled each other out. Then the defense made a key error. It may not have hurt them, but an error nevertheless to call Tracy Martin, the victim's dad. It was not necessary. They wanted to prove a point. He didn't give him the point, which is that he didn't say it was his son on the tape. And instead, the point left with the jury is Tracy Martin had lost his best friend. That was a net loss to call.
Okay, so the 911 calls and the scream kind of wipe each other out. The mothers might wipe each other out. A question that I had that I didn't understand, I know, Jeff, that you were there covering it for various outlets, including It's Your Call. We heard these 911 calls up until the shooting. What happens afterwards? Why can't anyone testify that if George Zimmerman is screaming, "Oh my God, I can't believe I shot this guy. Did you see him? He was on top of me. I had no choice." Is there anyone that could testify to that?
Oh, yes. The very heart of the defense case is the state's witness, Jonathan Good, who testified that he was outside and watched Trayvon pummeling him on top of him, first of all, with him down, with George Zimmerman on the ground, pummeling him MMA style. Okay, so that's the heart of their case. Is that
it's so hilarious to me about this pummeling, because there's the scientific evidence. The scientific evidence, which is indisputable evidence, indicates that the wounds that are on George Zimmerman's body that's supposed to exhibit this pummeling that he had is in fact superficial. In fact, they went as far.
Isn't that a picture of a broken nose, though?
No. In fact, she went as far as to say, she went She went as far as to say that caused that particular injury doesn't necessarily mean that there was an extreme amount of force that was thrown to his face to cause that. And if he did
how would you explain that? Take a breath for me for a second and explain that nose.
How do I explain it?
And the back of his head as well.
How do I explain? What I explain is that a young 17-year-old kid was fighting for their life.
Okay.
That's how I explain it.
Okay, except for one thing.
17-year-old kid. No, whether or not he was on top or bottom, he was a better fighter than George Zimmerman. That's what it indicates. He was a better fighter.
He's a better fighter than George Zimmerman. How's he fighting for his life?
What?
Because he's a better fighter than George Zimmerman. How is he fighting for his life?
Because some strange man at night was following him when he was going to his father's fiance's home.
So then he decided to take the crap out of him for following him.
He don't know what this man was going to do.
If Trayvon Martin hadn't been shot, he would have been convicted of assault.
This is what I'll say to you and Jeff, and I implore you to do it. Follow me, walking where I should be walking at night with a hood on my head, and you're following me and approaching me. I will pummel you as well.
And I don't know what happened. Trayvon pummeled George.
And if he did it doesn't justify killing.
Okay,
that's the evidence.
Let's find out what our viewers have to say about the evidence. Let's go to our Facebook page, which, by the way, is under Lynn Doyle, or Lynn, It's Your Call Doyle. We always like to hear from you. Gary has written in and said, "I think the defense was ahead from day one, even after after the prosecution's case was made, quote unquote, the defense was ahead, they introduced reasonable doubt themselves. I think he's referring to the state introducing reasonable doubt. And Rick says all along he thought the truth would be winning, and he predicted an acquittal. Sandy says the state could have done a better job with the audio tapes and with the victim's mother. Interesting that responding to what Sadie just said, she seems a bit cold to me. If you want to tell us what you think about some of the testimony, about the whole trial in general, you can email me at lynn@lynndoyle.net. As I said, we're kind of doing this review of the case, looking back. If there was something in your opinion from a defense perspective that you would have done differently, changed a bit, added to, not done at all, what might it have included?
I would have asked
The
the
defen-
I would have
the
asked the
defense
police to
opening
charge him
statement.
in the beginning and then
The knock
and then
knock
get the
joke,
charges
you would have
dismissed.
eliminated
The
the
knock knock joke.
joke?
I was floored. I was watching, and I just couldn't understand why he would. First of all, his delivery is poor. His case is good, but his delivery is poor. He's not going to wake anybody up. He's not going to win anybody over on a case that doesn't exist.
Okay, but that
telling a
knock-
knock knock joke was just
Right.
I never
Okay.
heard
The
of it.
opening,
17-year-old
everything has
boy
been reversed since
was
the
murdered,
openings.
and you're sitting here talking about a case that doesn't exist. A 17-year-old boy that did nothing but go home after going
Well, no,
to the store,
he
who was
attacked
shot.
George Zimmerman.
And who
Yes,
was
I'm
shot.
saying the case doesn't exist. That's what
Well, how
exactly
about talking
what
about
I'm
the
saying.
scientific evidence?
You
that-
always say retarded
that
things. So
Derek
I
is
don't expect
ignoring.
you to say something insane now.
One
me ask you a
second,
question.
one second.
Let me-
There's the foremost expert on pathology in the world testified for the defense, unrebutted by the state, that Trayvon Martin was on top of George Zimmerman at the time that George Zimmerman shot him. Well, guess what? That confirms John Good, the eyewitness. That's a doubt.
Except
whether you
that's
believe
not
it or
self-defense.
Okay.
It's
Oh,
not
no.
self-defense.
I would like to take your
Reasonable
head
force.
and bash it
It
on
ain't-
concrete. See
Although,
what you think.
although the defense expert,
Concrete is not
although
very
the
yielding.
defense expert who testified for the defense when was cross-examined by the prosecutor as, was his head being banged? Remember that dummy? You
It
talked
only
about
has to be
you
reasonable.
remember that dummy? When he was banging him
It
down to
only
that,
has to be
that
reasonable.
never happened.
You
Wait a
bang my
minute.
head on
That ain't
concrete.
evidence.
The
That
defense
will
does
never happen.
not. The defense
you
does
do
not
not
have
allow
to
that.
prove
Let's
self-defense.
not- let's not
They do
all
have
yell
to
at the
prove
same time.
self-defense. The Commonwealth, the state in Florida, has to disprove it, and that's a big difference.
Except this, Chucky, self-defense, it gives you you have the avenue to retreat. You still have to match force.
He's pulling
with
on him.
force.
He's beating him up. How you gonna retreat?
You still have to match force.
Excuse
with force. That's
me.
the difference between standing your ground and self-defense.
The
in
question-
Florida.
In the law, I agree
In
with you,
Florida.
but in facts, I don't think you're watching the
The
same
deadly
case.
I'm looking at law.
was
I'm not looking at
concrete.
facts.
The question that I
People rely
asked,
on
though, is
law.
what the defense, and I'm going to give you a shot at this on the other side, but what the defense would or should or could have done differently, in your opinion.
Very little.
We mentioned the opening statement, forget that.
Very,
you think
knock knock joke was the only
as it
thing they've
was?
done wrong. I mean, I mentioned Tracy
Only
Martin.
thing
We've
they've done
discussed
wrong.
it. We've been honest for the defense, telling you what their weaknesses were. But otherwise than that, this is the state's case. They didn't prove a case. The defense could have shut up and sit
And
down
not putting
and
him
never
on the
put a
stand was
case
a good
on.
move.
And
I
I
agree.
was just going to follow up with that. Would you have put him on
No
the stand,
way.
or did it
Absolutely
prove
not.
enough?
They didn't prove
Because
it, so why am I going to prove it for
The state
them?
made
Okay.
a key error by putting all the statements on, which relieved the defendant the responsibility of having to testify, which usually in a self-defense case you have to testify. The state gave him a free ride.
All right, let me turn to you then and ask you the same question from the prosecution perspective, how you might replay that game, so to speak. Everybody's a sports fan,
You
so
know,
how else would
interesting,
you do
the
it?
bad part about it is that we can sit around a table and Monday morning quarterback in terms of what our strategy would be now to infinitum, but we don't know what we would have done or what adjustments we would have made while we made the trial. The problem I have is that I would not have put any of the statements on. I would have baited him to taking the stand. If the statements
agree.
show, that's why I looked at you.
Thank
If the
you.
statements show inconsistencies, then I want those inconsistencies to come out when he's before the jury. So
Okay.
I'm not gonna say what George Zimmerman said. I'm gonna allow him to get on that stand because, but for that, you have no self-defense claim.
The
Okay.
problem is when you pick and choose among the statements, because you got to put some of the statements in to make your case. You open the door, and if one comes in my mind, they all come in, and that's the problem that you
I
have.
don't think you have to put him on, though. I think
Well,
the
but-
911 tape from Zimmerman, when he's being instructed not to follow him, and he's making the statements that he's making,
Right.
and then
Otherwise,
the
they
end
were
result,
self-serving
We
statements.
don't have. We don't
I would
have
have to say
anything
that the
else.
prosecution raised self-defense
Right.
themselves.
Okay.
They did the job for the defense.
And
On
they
that note,
gambled.
I'm going to take a break. We're going to take some more of your thoughts in just a moment. We're also going to hear from our panelists and see what they think the future is going to hold when it comes to other cases like George Zimmerman's. We'll be right back. Stay with us. Thanks for joining us once again. I'm Lynn Doyle. This is It's Your Call. We are taking a look kind of point by point at the George Zimmerman murder trial. As you know, he's the Florida man who has been on trial for shooting a 17-year-old black African-American, that's obvious, who lived in that area, and he had called 911. He had reported a suspicious person, and then they kind of, their paths crossed, and as you know, then Trayvon was killed, regrettably. Now the question is, what happens after this case, what the reaction will be to the verdict, and what happens moving forward. I know you're very passionate about this, Tyreek, and I know that that passion is reflected all across the country. Do you think that people will be more aware of these kinds of cases now and continue to demand them to go into court? A lot of people feel that the George Zimmerman case came into court as a result of public outcry and not necessarily state evidence.
No, absolutely, and that's part of the problem. Had they arrested him and then allowed this process to go forward, we wouldn't even be looking at a Zimmerman trial. It was an appearance that in fact, because of who his father was, where they were living, the fact that Trayvon Martin was an African-American teenager, that this was going to be swept under the rug. And that's what's so incensed to me. See, I have a 13-year-old son. And I'll tell Jeff and Chucky and anybody else that want to hear it, if you think you're going to walk behind my 17-year-old son, who's not doing anything other than being a 17-year-old African-American teenager walking from the store, and you're going to approach him, and then as a result of you approaching him, you're going to kill him, and you think that you're going to walk away, don't worry about them. It wouldn't have been a trial. You know what the trial would have been?
You.
State versus El Shabazz.
Yes.
Yeah,
That would have
you're
been the
skipping
trial.
a major chunk.
What's the chunk?
He didn't just follow him and then kill him. You're skipping a major
What's the
chunk.
chunk?
Then the guy turned around and beat him
He
up.
invaded his space,
No,
Chucky.
you don't know that. You do not know
You're allowed
that.
to beat somebody up for invading your space?
No.
He had to
Trayvon
be
Martin
close.
could have approached him, which is probably
After he
what
followed him, how
And
long?
even if
Look,
Trayvon
following-
approached him
fo-
and
He's
hit him,
going home.
and
You let him
hit
follow you home,
and
Jeff?
beat him, are
Let him
you
follow
are
you, see
gonna
where you
tell me
live?
that a
Stick-
gun
Don't
is
be
a-
kidding me.
Stick on the
that.
point, and the point here is
That
this,
is the
that-
point.
No.
That is the point.
I think the point in the jurisdiction that I practice in, we have a duty to retreat, as most states still have.
Florida has that
But-
too.
But no, in
your
Florida
ground.
has no duty.
No, Florida has a duty to
No.
retreat in self-defense. That's the distinction
No.
between, and that's what. And you
No,
know
they
what?
don't.
You
No,
know what
they
we're gonna
don't.
do? You
They
know what
don't.
we're gonna do?
They don't.
You know how we're gonna resolve this?
They don't.
We're gonna pull the law.
right.
But I'm gonna
All
tell
right,
you,
but they
as
don't.
I-
Okay.
and you can
The
say
whole point
that.
is-
Hold up, let me finish my point. You said
Well,
they
they're
don't.
gonna still
The
say
point
the
is,
law is
the
something
point
it's
is,
not.
no, you're saying the law is something it's not. That was the distinction. Stand your ground. There's this difference between
No.
standing your ground. There is no duty to retreat.
All right,
But in
as I
self-defense,
said,
there is
No,
a
there's
duty.
no-
to
This is a
retreat.
very passionate case. If anything we're going to learn from this, it's that there should not be profiling in any situation, and that if you're
It's
a
all right
George,
if Jeff said it's okay.
if
You
you're
can profile,
if
you can
you're
follow, you
George
can do anything you
Zimmerman
wanna
and
do.
the 911 dispatcher tells you to stay put, then you should stay put. I mean,
No, Jeff said it's
No, no,
okay. You
what
don't
I
have to
said is
stay
they
put.
should
You
review
can go ahead
stand
and
your
follow.
ground.
You don't have to stay
Right.
put.
That-
They
that's
really
what-
should review
Look, this
stand
was an
your ground because it's an
overreaction
imperfect
But it's not
by
stand
one
your
man,
ground. They didn't
an
use that.
overreaction by the team.
That's not applicable here.
either
was-
way,
Jeff,
it was
either
a
way,
bad
it's a
situation.
tragedy. It is a
Respectfully,
tragedy.
carrying
Let's
weapons and
agree on
not
that.
having to
You
retreat
do
is the
not
problem.
bring a gun to a fist fight. That is
No, but the
wrong.
law
we don't bring a gun to a
allows-
fight at all. He
Bring a gun
carries
to
the
a
gun all the
fist fight.
time.
All right, guys, we are almost out of time. As much
That's
as
what the
I
problem is.
love to have you all back and in full force, it's a pleasure to have you all back in the same room and
Shut
hear
up,
your
right?
opinions. Now, I want to give you really quickly acquittal or conviction, because we're going to follow this case and I want to see who's where and how strongly you feel.
Acquittal on everything.
Okay, over here,
Manslaughter or hung.
Agreed.
manslaughter or hung.
hung.
Okay,
Agreed.
and Chucky,
Not guilty.
not guilty, acquitted.
Acquittal.
Acquitted.
Okay.
We agree.
We may use that tape later. But in the meantime, again, thank you so much for being with us. Certainly always wonderful to have you join us. If you were unable to get through and tell us what you think, as I said, you can find us on Facebook or you can email me directly at lynn@lynndoyle.net. I know you're going to have a lot of comments for my guests, so you can send them to me and I will forward them and they'll be gracious enough to respond to you directly. We'll see you the next time, everyone. Thanks for watching.